All right. Hello again, everyone, and welcome to another training session from the Office of Loss Prevention on orders to show cause. I was requested to do this by one of my fellow emoluments, and here's I'm going to present you the information based on my research and experience. So, when I get emails from clients, the connotation behind the email after reviewing the dictionary is they are reflective of more so this definition, right? The cause without which an event could not have occurred. So it's kind of sort of, I would say the actual show cause order would have evolved from this 1924 concept, because when you look at the definition of show cause in the dictionary from 1925, these two things clearly correlate. So in order directing a party to appear in court and explain why the party took or failed to take some action, or why the court should or should not impose some sanction or grant relief. So that's pretty much the short version definition. So many times, as you've heard me utilize this particular legal maxim here at the bottom of the screen, the cause of the thing causing is the cause of the effect. Okay. This seems justified and appropriate to put this one here because I've used it so many times. And I'm hoping as I go down through this presentation, it kind of give you an idea of why I get to granting relief as opposed to a sanction. So, always, I'm going to try to interject a little humor into something like this, simply because, well, those of you who've been around long enough, you guys just pretty much know how I am. And I try to break into a little bit more redneck-and-ease for some of the, newer folks. So today's word is twerk, and I guess it's back to work. And moving on. So one of the things that I primarily focus on is what's in the tangible. Can I see it? Can I touch it? Et cetera, et cetera. In so much as that, we get into the rules of evidence. Under Article 1, scope and definitions, okay, tells you these rules apply to proceedings in the United States courts. The specific courts and proceedings to which the rules apply, along with exceptions, are set out in Rule 1101. So in so much as the definitions, you'll see I've highlighted public office includes a public agency. You've heard me talk about agency practice. So why I recognize the articles of these agencies and their practice inconsistent with the letter of the law. I mean, I don't know any other way to verbalize it other than to just say it that way. So anybody in public office, position of emolument, whether it's real or imagined, know and understand that you're subject to the rules of evidence. And it's right here, Rule 101B3. So you can expect some scrutiny as you go to work every day, right? So because the expectation by the public is you're supposed to be doing a job, or we're supposed to be doing a job that better meet the expectation. So that's when you get into performance and relative other things. So what does Rule 1101 say? Rule 1101A, these rules apply to proceedings before United States District Courts, United States bankruptcy and magistrate judges. Notice it didn't say the courts, it said to the judges. So don't put things in there that don't belong, and don't take things out where they should be. United States Court of Appeals, the United States Court of Federal Claims, the District Courts of Guam, the Virgin Islands, and the Northern Mariana Islands. So these are the locations, and I want you guys to kind of focus on United States Court of Federal Claims. It's not the United States Supreme Court. I've heard people ask me that, and it's not the same court. The United States Court of Claims is an altogether different court. Referral to such court is more oftenly comes from a delegation through the legislature, which is why you file your grievances in the legislature to achieve the appropriate jurisdiction. So to cases and proceedings, these rules apply in civil cases and proceedings, including bankruptcy, admiralty, and maritime cases. Well, admiralty and maritime, those are contracts. So what do we know about contracts, right? Contracts that are written in, contradiction to the law are not enforceable. They're void. So I'm going to focus primarily on letter C here, because now we're getting into privilege. And many of the family rights activists are going to be coming to you with the understanding and the clarity that rules of privilege apply to any relationship between a husband and a wife. End of discussion. Government is a fiction. It is a piece of paper. It cannot have a compelling interest. Period. It is what it is. So without in the absence of obvious, a dead body or an obvious victim of some sort, but to just walk in and claim that you have some interest in something, that's arrogant presumption at best. So under the rules of privilege, that relationship is protected as it is between a parent and a child. You cannot interview a child without the parent present. Attorneys that are telling you this are wrong. They're going to get you in trouble. They're going to get you fired, and even worse, could get you sued. So don't take any bad legal advice from the fourth pillar. So even so much as under the exceptions, right? The exception to the exception is privilege. Privilege applies everywhere to everything. So if the relationship is privileged, it's out of bounds in court. End of discussion. I'm going to say that one more time. If something falls under the rules of privilege, it's out of bounds in court. Period. So other statutes and rules, again, we're going to debate a little bit on who even statutes apply to. If you read the Peterson case, statutes are not law. So then what role do they play? It would be, my short answer is nothing more than guidance. But judging by who's writing them, I would just avoid them altogether. I've done a video on policy. I would say take some ethics review committee, and you can duplicate what I did, which was I quoted the policy, or I'm sorry, I quoted the, what came out of the committee, and I wrote policy in accordance with the rules and what the committee said. So also understand that where I put in here, be further advised to the extent of limitations on the admission of evidence as previously established, outlined in the exclusionary rule and fruit of the poisonous tree doctrines. This is actually a quote from that policy to which I was just speaking. So right of discovery, Brady materials, right? Exculpatory evidence. Be prepared to be getting tons of this. And I'm going to say this for the 1,000th time. Anybody who is a potential client of this office, anybody ever tells you to give them your evidence, don't do it. I have a rule about that. Send copies, you retain the originals. And the reason is because we're talking chain of custody. As long as you retain your original evidence, you retain the standing in law with the right to a cause of action. So to recap that, as long as you retain your originals, you remain the full authority, sovereign authority, to exercise your right, in your standing in law to a cause of action. So now that we've got that clarified, where legal doctrine falls with respect to the rules of evidence. So go back to the Rule 103, preserving a claim of error, right? No, in some areas and even some states don't even have a court of errors. So that may be, you might be referred to a court of claims, right, to resolve an error. So why? Because an error of law injures. It's another one of those maxims that's on the short list. So here's the criteria of preserving a claim. And letter B, not needing to renew an objection or offer of proof. Once the court rules definitively on the record, either before or at trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. So even if you're denied in the court, you can still take that appeal to the legislature, and there's process for that. There's actually motions and appeals in the legislature. So those lists of motions are in front of Masons. And it's an easy way to get to expungement. Let me just put it to you that way. So whether it was one of those things where it's a way for a judge to throw in a bad lawyer under the bus by intentionally committing an error that would warrant expungement, hey, more than one way to skin a cat, right? So before you go out there and start arresting people, okay, make sure that what we're talking about is, under evidence is relevant and within its limits. So there's a test for evidence, which is good. Anybody in the second pillar, and as many of you now know, I refer to law and government by what in its branches by what it is. It stems from the pillar. So those of us in positions of emolument, we're primarily in the second pillar, the executive branch. So the test for relevant evidence is it is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence. And the fact is of consequence in determining the action. And of course, under general admissibility of relevant evidence under Rule 402, relevant evidence is admissible unless any of the following provide otherwise. So United States Constitution, right, federal statute, these rules, hence the rules of privilege, other rules prescribed by the Supreme Court. And of course, irrelevant evidence is not admissible. The reason I put, I even posted Rule 402 was because you're going to hear, somebody said that, for example, if you had a DUI 20 years ago and you got a speeding ticket, today or whatever, and the prosecutor would bring up, he had a DUI 20 years ago. You could object and say, Your Honor, what happened 20 years ago is not relevant to what's going on. I motion to exclude, motion to strike. So that would be a way to, kind of throw him under the bus a little bit, put the guy back in his place and let him know that he's not as smart as he thought he was. So another one under 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. A lot of times they're going to say, it's relevant, but it's a waste of time. And they'll get away with that by Rule 403. Well, again, if privilege applies, objection, Your Honor, move to strike, privilege applies. period. It is what it is. So this proves the privilege. It's not a waste of the court's time. So, you know, if it happens to prejudice the court against the prosecutor, yeah, so what? That's what extrinsic evidence is supposed to do. Too bad, so sad. So let's get into Article 5, privileges. There's actual rule for this, 501, privilege in general. Coming from, here it is, say it with me, the common law. There we go. That'll satisfy, I hope, hopefully satisfies the common law group out there. There's plenty of you. So the common law, as interpreted by the United States courts in the light of reason and experience, governs a claim of privilege unless any of the following provides otherwise: United States Constitution, federal statute, or rules prescribed by the Supreme Court. But in a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision. Now, you're gonna have to be very, very careful here. That's that last sentence, but, one begins with but. I think that is an attempt to usurp the privilege. So, you know, again, be prepared to do battle between, you know, with arming yourself with the knowledge of Rule 501 in conjunction with Rule 1101. And remember, these are the rules of evidence, right? So this is not criminal or civil defense rules. This is evidentiary rules. So one of the reasons I'm going into the evidentiary rules is because here in the second pillar on the clock, hence the joke, one of my defenses, the affirmative defenses, is injury by fellow servant, right? Hence the work that I did in proving that all of this is Sharia law. Yes, it's the elephant in the room, and yes, I'm going to call it out. So accept it, know it, understand it, deal with it. And because of that, it presents an actual fraud, right? Because nobody ever discloses this. And if disclosure is mandatory, Brady, guess what? Their case fails. So it clearly falls under an act of fraud, actual fraud, which is a concealment or false representation through an intentional or reckless statement or conduct that injures another who relies on it in acting. That's one of those ninth principle of group decision making. It's one of those things that we never even have to litigate. It's just there. Don't commit fraud. Excuse me. So, in so much as extrinsic fraud, going with the legal maxim over to the right, a latent ambiguity in wording is resolved by evidence. For whatever ambiguity arises from an extrinsic fact is resolved by extrinsic evidence, right? Something in the tangible. So, intrinsic fraud's a little bit more difficult to prove. It requires a very clear and concise fact pattern. Can be done, very difficult. Stick with the extrinsic, just based on my experience. If you want the judge to be able to look at it and say, oh yeah, okay, you're right. Yeah, no sanction, I'll grant the relief. Boom. So, you know, again, just trying to help you out with that. In so much as the extrinsic fraud, the reason that I'm going here is because it's not so much the first definition, it's the second one. This is a fraud that prevents a person from knowing about or asserting certain rights, hence the liberty interest, remember from the impeachments video. So liberty interest is fundamental right. So if they're purporting some rule, right, as a means for you to not assert a certain right, it's still extrinsic fraud. Objection, Your Honor, extrinsic fraud. See definition 2. Tell them I say hi. You can blame me. I'm getting used to it. So, into the rules of contracts, rules of admiralty, blah, 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 blah. Contracts inconsistent with the Constitution must be assembled and discharged as mandated by the Magna Carta and succession of law dictates. Now, The reason for the implication of the litmus test here, everything above the line, which is the line being the white space between the red and the blue horizontal lines there. When I say above the line, below the line, what I'm talking about is right there with 0 times 0 being at center of it. And this is 0 times 0 is my joking code of X's and O's saying, yeah, even in, it's still a matter of, even in tic-tac-toe, 0 was 0. It still goes to 0, period. So the Constitution, of course, is what lays out everything above the line. Color of law. Been through it. Go back, go through it again if you wish. Jurisdiction of this office is shown in the upper right quadrant, 28 USC 1443. And of course, that is an example, just kind of a quick visual of what my company would look like if I were to put it on paper. So just so I said, sort of a snapshot. Oh, okay, yeah, I get it. The Title IV stuff and the emoluments of statutable plunder, stuff in the quadrant number 4. Notice how those things, I keep saying reverse the pump, because that is nothing more than a perpetuity. So, it's just, it is what it is. You're going to have to just deal with it and move on. So the problem, what is the problem? Well, Article 1, Section 9, Clause 8, and the proper 13th Amendment in context. So who has the problem? We the people. Why should it be solved? Personally, I like this maxim of law to answer that question. The reason is obvious. And how will you know this problem has been solved? Well, some form of impeachment, some form of resolution, and of course, some form of expungement. Those would be my 3 primary criteria, units of measure, to gauge whether the problem was solved or not. Going to kind of get into some of these questions of, what was my research, how I discovered the problem, how I got information, interviews, personal experiences, et cetera, et cetera. So here's how I discovered the problem. Right? You're going to hear a lot of this. Well, they're an oath taker. They're obviously bound to the Constitution. That's an accurate statement. And the reason we know that is because when you pull your oath of office off the wall, you see that word underlined in red? That makes me on the clock a constitutional provision, hence injury by fellow servant. See the problem? Emoluments of statutable plunder. Okay, so again, the necessity overcomes laws and overcomes law and laughs at the fetters of laws. So I've said, look, this would even fall under inevitable discovery. It's not a hard sell. So in so much as the letter of the law is referenced in the previous slides, there's the Article 1, Section 9, Clause 8, and there is the proper 13th Amendment that specifically mentions foreign power. It is what it is. So, and again, you're going to hear a lot of whining and crying from the 4th pillar and the 5th pillar. This guy's claiming to be something he's not. Well, hogwash. I got an oath of office that proves it. So when President Trump issued Executive Order 13781 asking for help from the citizenry, those of us on the clock, figure out what's going on with the executive branch, might as well say I've been drafted. So I'm okay with that. President asked for my help. I think I'm pretty much duty bound to offer anything I can give him. So one of the things that I do is I created this company. Even the wife said, go to work, solve this problem. Okay. You may not like the answer, but I'm going to do the job anyway. So this is what your basic company structure looks like. The CEO, CFO, president, vice president, pretty much whatever it is. In the private sector, we don't differentiate between the president, the vice president, or chair, CEO, and CFO. In the private sector, we're a lot more liberal about this. Neither one of us will make a move in the executive side, either CFO or CEO, without the other one's at least agreement and knowledge of what's going to happen and why. It's just one of those things that makes a company succeed. So when the board meets, when the board of directors meets, hence Congress, okay, I'm going to kind of break down the board of directors a little bit because they do play a role in what we do. And here's the role. So there's no such structure. So yours, meaning your company, can be constructed as you so desire, depending on your company's needs, right? Or how large your company is. So split boards of directors separating operations and finance. And it's not uncommon to do this, because even in the United States Congress, the mirror there is House of Representatives controls the purse. Senate would be the operations side. So in so much as a corporate structure, the finance side would work primarily with the CFO. The operations side would work primarily with CEO. Hopefully that makes sense to you. So inherently, this is why businessmen make better politicians than bar members, because we understand this thing. It literally is like going to work every day. So keeping it simple, will aid in any potential audits or other periodic inquiries as they may occur without a lot of advance notice. You can also use these processes to your advantage if you run things properly. There's no better witness for oversight on your behalf than a well-executed government audit, which finds no fault with your company or its business practices. Hence my standing joke. Is it legal or is it lawful? If it's not lawful, it sure isn't legal. So there's benefits to keeping things lawful. So, excuse me. To whom should I apply the fiduciary duty? This was one of the questions that I asked the board. Why? Because as of June 1999, was licensed in commerce. By the way, this is what a license looks like. So if somebody hands you a bar card, it's not a license. This is what a license looks like. These are things you can verify. There it is in the Department of Commerce, doing business, contracts, right? So now that we're understanding, right, the difference between a credential and a license, which I'm going to show you what a credential is. Credentials are most often limited to a specific skill or industry to perform some specific task in compliance with a law or policy directly related to that industry's standards. So we, without going into a long-winded example of how we do things in this business every single day, let me just put it this way. If we don't follow our specific rules and how we do business, there could be serious environmental consequences by us not following our own set of rules. Now that we've clarified that, this is a reason these credentials exist. So when you're out hiring and you're looking for somebody who has specific sets of credentials in some specific business, if they have credentials unrelated to your business, it's not so much relevant that credential is unrelated as it is the fact that the person that you're looking at took the time to get a credential that was related to something that they were doing. So it shows the credential does lend credence to that this person, number one, is somebody who's trainable. Number two, it's somebody who's going to put forth some effort to do the job the correct way. Not necessarily so much a yes man, but it's somebody who's going to give you answers that you can depend on. So not even, sometimes they're not going to be what you want to hear. Hence this slide, right? Part of my research was parliamentary inquiry. What emolument is that? So again, go back and watch Bill Barr's confirmation hearings, and you can hear very clearly I answered Dianne Feinstein when he said, beyond the dictionary, or how did he put that? Something to the effect of his first thought was it would be a stipend attached to some office. So that's why I said there's where the comparison and contrast between subsidies and stipends came in. Subsidies happen under contract. Once the contract is fulfilled, the subsidy reciprocity is applied. So stipends are on the clock, period. So hence the joke of on the clock, off the clock. So this exact slide here, I'm not going to go into it again this time. I've explained this in multiple other videos. This was just the science, a short answer visual of what I believe to be the most tangible as to what's caused what we're dealing with right now. It even works in so much as the math. So, because you can never deny the math. Now, knowing and understanding a way to end up dealing with ethics violations leading to competency hearings. A couple of principles that may be applied to that is outward acts indicate thoughts hidden within, right? So if you're going to go around spewing some ridiculousness, okay, you can expect probably a competency hearing or an interview with HR or even worse, internal affairs, if you're in the second pillar. And of course, the intention is punished even if the object is not achieved. So just cover your butts and help each other, keep each other calm during all this, because we know these people are going to try to bait you into something. So those of you who have successfully completed the training, such as myself, we don't fall for that kind of nonsense. We were born at night, but it wasn't last night. So in so much as the information, research materials, Annals of America, Jefferson's Manual, Mason's Manual, Robert's Rules, and Law Dictionaries. These are the primary sources of research material, obviously beyond the state's constitution, which should go without saying, I would hope, but in so much as what a republic is and how to use it. Okay, these would probably be the best sources of information that you can use to do your job. Okay, so in the performance of your duties, you know, again, to know a thing and to be bound to know it are regarded in law as equivalent. Well, are you technically bound to know it? Yes, you are. Might as well just say it's an elephant in the room. Yes, you are. Why? Because that's the color of law, republic. If you're going to enforce it, don't you think you ought to know it? So knowing and understanding that when you file a petition for prosecution or some form of to a court, that comes from this section in Jefferson's, if we're going to use Jefferson's. The person off the clock, the remonstrance, is the person who has that doesn't require a prayer. So you don't have to pray for you know, again, the public, they're the sovereign. They can walk in and say, I'm not here to ask you, I'm here to tell you. Guess what? They have that power. Know it, understand it, accept it, deal with it. So, impeachment. Now, we're not always talking about impeachment of the actors, but go back to the rules of evidence. There are ways to impeach a case, right? Some new piece of evidence comes up, right? That would impeach the validity of a conviction or prosecution, for that matter. So, multiple interviews with clients. I have found more causes to impeach cases than Hershey's has M&Ms. I'm just going to put that out there. And the good news is it's not even a bad thing for the court, because unfortunately now with this Sharia garbage on the books, technically speaking, the court's in disrepute. So it can do two things. It can either discharge or it can grant standing and mandate the standing. That's really the limitations of what courts can do right now, while the court is in disrepute anyway. So knowing and understanding that this was the attack, right? The attempt at domestic violence, internal insurrection, blah, blah, blah. I'm not even going to go into it because it gives me a headache every time I think about it. Hence did somebody seriously step on a Lego joke? So this is one such client, right? And mandates were issued in both of the cases. My case, which is the one to the right, and his to the one to the left. So it is what it is. And the client on the left was where we actually got the jurisdiction, because we said, hey, look, we don't want murderers, rapists, and other bad actors out on the street either. We just want these jackwagons that leave us alone. So hence the injury by fellow servant. So two other cases. One, the left one is resolved, the right one is still ongoing. So knowing and understanding what's going on here, the one on the right, 4 states. So I said I thought I had it bad. That's what, I'm not even going to go into it. I'm just going to make my upset myself. So personal experience, all private sector business and modeling, hence what you see to the right. Systems analysis and practical assessments. So if I were going to put into what a systems analysis and a practical assessment would be, the center, Republic, and of course the triangle, and of course the Star of David below it. The one on the bottom should kind of give you an idea of what the credentials by this office offer, right? There's fiduciary status dating back to in business since 99, standing to present, right? As a notary, part of the job of the notary is to do what? Ensure the truth in the record. It is what it is. So that's the judgment call, or some of the judgment calls that I've had to make over the years. So when the judge issued the mandate in standing, that pretty much added, well, that connected as you see it here. So me being me, I still say full disclosure is a requirement, hence my constant beating Brady to death, right? If we're going to be honest, let's be honest about it, start to finish. So that's full disclosure. It is what it is. So in so much as what you're going to hear from a lot of these fake 5th pillar and 4th pillar actors, you can just simply respond like this. Just, if you have to arrest them, you have to arrest them. It's just, again, it is what it is. You're not, anybody who's walking around without their head in their rear end is not going to be offended. Let me just put it that way. So in so much as personal experience of this office, again, knowing the process to make presentations, in the context of either daily business or due process of law, depending on what it is, it still comes from, where we're going here, section 41 of Jefferson's, right? So you get in divisions of the House, right? Speaker divides the House, blah, blah, blah. File your articles, Senate tries the articles, orders the investigation. What we saw happen pretty much primarily during Justice Kavanaugh's confirmation. There is even a flow chart. Okay, kind of gives you sort of a broad overview of how this is supposed to look, how it's supposed to work. Those of you who like flow charts, this should be a very good slide for you. Those of you who like the verbiage more than the flow chart, we've got you covered there too. So here's the verbiage that goes with the flow charts. I'm not going to go through and read the entire thing, but it is what you see italicized, starting with, but in both houses of Congress, all these intricacies are avoided, right? So those are things you might want to pay close attention to, because it's italicized for a reason. So in so much as the operative, right, taking the theory and putting it into practice, paying a little extra attention to things that are italicized are going to be relevant to you in the second pillar, because remember, we are the executive execution branch. So going back to the litmus test, right? Choose the best workable solution and create a plan to build a prototype. Here's my prototype. Okay. Went through the materials, what the materials were that went into it, showed you those. And of course, will your prototype be an actual size or a model? I prefer models. Okay. So in so much as this, your brain may have gone to, well, we're not building a car, and you're right about that. So the thing about models like this on paper is models are going to change and evolve. Sometimes you keep the original model, right, as a reference from the original project as you evolve. And one of the reasons that you do that is because you always have a baseline from which to proceed moving forward. So, workable solutions for discharging known theft, because that's what this is. It's all known theft, right? Just, again, it's an elephant in the room. Call it what it is. So, in the performance of a specific job description, under solution 1, solution 2 is discharge the duties of the offices, and of course the bills of attainder that go with that, because we know that's what this is, hence the reason national debt was where it was. And solution 3, zero and close the accounts. It's single, or it's easy as 1, 2, 3, seriously. So don't make it more complicated than what it is. Again, to break these down a little further, the common denominators related to orders, right, in so much as compliance with a lawful order, yet if in the terms conditions of a contract are not lawful, any subsequent enforcement fails. So when people bring you Brady materials and they say things to you like, hey, I'm not following an unlawful order, so get an order coming out of a Title IV court, it's not a lawful order. Might as well take it and shred it. Don't enforce it. It's not law. It's Sharia law. So what they're asking you to do is commit treason against the Constitution. Don't do that, right? So helping you out here. How do I know that? There's 2 legal maxims that support this. A person acts contrary to law who does what the law prohibits. Again, this happened in 95, not our fault. A person acts in fraud of the law who, without violating the wording, circumvents the intention. Well, again, once we have, somebody who actually broke the law, hence injury by fellow servant, right? There can't be a lawful order. That's why I said the thing was designed to fail. So, get rid of it. And of course, always in doubtful cases, that is to be done, which bona fide contract may be the safest condition. Again, with the exceptions, except when it has been drawn up clearly contrary to law. Why have these been these marriage contracts drawn up clearly contrary to the law? Because the relationship falls under the rules of privilege, as stated earlier, right? So anything related to family law is fraud. Period. It is what it is. So what I don't understand is why these damn things even still exist. We should be in there shutting them down, throwing these actors who are claiming to be magistrates or whatever kind of a quote unquote fake authority they are, throwing them out, put them in handcuffs, throw them in prison, 30 days in jail for stupidity. I don't know, either way. Anyway, solution 2, the political arguments. Domestic violence, doctors, and vaccines. These are not judicial arguments. These are political arguments. It is what it is, right? So what impact do these foreign emoluments / markets have on domestic emoluments? Well, again, look around you. That simple. The math between quadrants 1 and 4. So I said, it's either way, it's still 0. Right? You're discharging the duties, you're performing a specific task, and you're still discharging it. That's what the oath of office is supposed to do. You're supposed to discharge the duty. So what I want to know is, who is the jackwagon who has standing to claim a right to a cause of action to even charge you to begin with? That would be, I would say that'd be a fraudulent money transfer document. Wink, wink, nudge, nudge, Secret Service. Hence the reason I sent this up to you guys for plug this into the mechanism and say, oh yeah, there's your fraudulent money transfer documents, those bonds and all that other fake stuff. So in the no jurisdiction, this is us out there in the private sector, the tax for profit subsidies, right? These are the ones in blue, that's us. In these junk sciences, hence domestic violence, where they say, you don't know the law. Really? Yeah, you're right. I don't know your crap. Don't care to know your crap because it isn't law. Here, see Peterson versus Peterson and how many other cases ago that are right along just like it. Shuttlesworth versus, I think it was Shuttlesworth versus City of Alabama. State converts a right into a privilege. Person can, the public can engage in the conduct with impunity. It is what it is. Just, these are things that we should be, that we should have been taught that we weren't. So the good news is I did much of this homework for you. So, in redesigning prototype as you move forward, right? These are some of the things that you might want to keep in the back of your mind, just kind of, sort of a test for you to say, okay, I did this. Here was the base model. I did this. It either worked or it didn't, and why it worked or it didn't, right? And, kind of help you, build and grow as you, proceed with your, whatever it is you're doing. So, entering the proper diction pursuant to the following, right? So I said, knowing what should be in the four corners, you're going to see multiple versions of this, right? As long as you're following the theory of the four corners rule, you're pretty much within bounds. Mine is simply this. Starting from the left as the house, right? The house of, right? Somebody with doors. Bottom left, the man in the private, off the clock. In the bottom right, the man on the clock, still in the private. Ish. We're still working on that. Anyway, top right would be the date. One of the reasons that I date materials, one of the reasons bar members don't, let's just put it this way. Time rules events. It's a maxim of law. So by not putting a date on something, they are attempting to, well, we don't even know when this started. Well, when you look at my documents and many of the people who follow me, my clients especially, they're going to be, their materials dated. Count on it. I'm kind of a stickler for it. So expect to see dated materials because I don't want there to be any more, there's not going to be any confusion coming out of this office of that. You can be guaranteed. So without going into rereading this is just pretty much the short version, right? This section specifically, right here, almost in the center of the screen, pretty much kind of gives you the gist of what this issue really was all about. So that, the law, we're done. Now, your mindset moving forward should take on this connotation as you rise and report, right? So you can properly discharge your duties of your offices. It is what it is. So any of these charge sheets, right? You can't issue a charge sheet without clear and convincing, not clear and convincing, beyond reasonable doubt evidence of a crime. So this clear and convincing crap, this is a foreign emolument. It's a foreign evidentiary standard. Don't do that. It's not in compliance with the rule of law. Why? Civility, we have preponderance of the evidence. That's civil stuff. Beyond reasonable doubt is the criminal stuff. So if you can't prove it beyond reasonable doubt, don't touch it. In accordance with Executive Order 13781, which established this office, by the way, my suggestion for modifications to the Florida Executive Departments are as follows. Now, this is mirroring Texas. And why? Because in Texas, the Texas Rangers, when they were created, their job was to look for cattle rustlers, right? And work liaise between the county sheriff and federal authorities. So following that same premise here in the state of Florida, where we're surrounded on three sides by water, granted, we don't have much cattle rustling, but we do have we have more than a few ports of entry. right? Airport notwithstanding, plus the reactivation of the Space Coast, right? There's a lot of, the, Port Authority, Customs Enforcement, that kind of thing. Those people need to be right where they are, right? And they need a backup mechanism to transfer whatever bad actors, cargo, whatever is intercepted, right? Without leaving their post, right? That could be a potential failure in a defense mechanism if somebody has to leave their post for a long extended period of time to go transport something from Miami to Orlando, for example, for whatever the reason. And, and so on. So the implementation of a state marshal's system, they can back up the sheriff, the county sheriff at the county level, and plus they can also work with federal authorities throughout the state, right, to kind of help liaise, right, and back each other up, not getting so much into the jurisdictional pissing contests, right, as it was typical with the police departments and the sheriffs, right? So we don't throw the baby out with bathwater. We got a lot of good trained individuals out there. Let's just give them a job that is commensurate with their training, right? And put them in a position to where they can be most beneficial to society. So it is what it is. Why? Because where there is society, there is law. It's a maxim of law. Deal with it. It is what it is. So, in so much as why I think this suggestion is not only feasible, but it's going to solve a myriad of problems is, we're going to end up not having to, again, getting into these local jurisdictional pissing contests over something as silly as a traffic accident versus, being able to efficiently and effectively, right, move bad goods or bad actors through the system for, discharge of whatever the problem was that they had. So the final result, again, each according with his or her gifts. So the one thing I want you to take away from this is if this works for you, good deal, right? But either way, reflect on how you feel about the process from start to finish in this project or whichever one you're working on, right? Reflection is a good tool. Helps you do your job, helps you be very effective. So very effective. So thank you for your attention. Should any of you wish further clarification or oversight on this matter or any other, you may contact me directly as follows. Mailing address is here, phone numbers here, email is here, Dropbox for file sharing capabilities is available. I'm actually working on setting up an actual private server. No jokes about Hillary Clinton, please. Either way, this way, it'll be something outside of the Gmail system simply because I'm aware of what's currently happening with all that. So again, as resources become available, hardware becomes available, that will also become available. So, but in the here and the now, in the short version, it's not broke, don't fix it. If you don't like the electronic system, you can always use snail mail or overnight. So anyway, thank you for watching. I hope you found the information helpful, and I guess we will see you next time.